Good evening. Welcome to the show tonight. I'm Yvonne Okwara Matole. The big story of the day continues to unfold and develop across many platforms and in different ways today. We've got just 15 days to that election. Will it happen today? Some renewed hope after Dr. Ekuru Aukot, who's the Third Way Alliance Kenya presidential candidate, got reprieve. In fact, it was a win at the High Court today after Justice Mativo compelled the IEBC to ensure that he is gazetted as a presidential candidate for that matter. And of course, after that news came in, a lot of follow-ups that came up. We've heard former presidential candidates Japheth Kaluyu Kavinga and Mohamed Abdu Badida now saying they too will be on that ballot that is scheduled for 15 days from today. All of that while Parliament passes the amendments to the electoral laws, and that now goes to the Senate for the next step. And still at the courts of law today, activist Okoiti Okia Omtata going there to say that there is a lacuna, that the law isn't clear as to what happens when a candidate withdraws. We will be speaking to him as well, and he's seeking to bar the IEBC from declaring Uhuru Kenyatta elected unopposed. All of this while the IEBC continues to seek some legal representation, or rather some legal counsel and interpretation on the way forward. But back to our big story tonight, and it's that big win for Dr. Ekuru Aukot. Here's his reaction outside the courts shortly after that verdict.
To relish this moment, enjoy the opportunity we've been given, and definitely confirm to Kenyans that we shall be in that ballot as it's been ordered by the High Court. And I want to
Yeah, so elated, talking about upholding the Constitution. He should know he was one of the drafters of the Constitution of Kenya 2010. We'll be speaking to his lawyer, Elias Mutuma, in just a moment, getting some reaction from him and some understanding on the way forward. Also, we'll be speaking to Okoiti Omtata on his petition that is at the courts of law. How is all these things going to affect that election that is coming up in just 15 days? Sophia Wanuna, our lead reporter, also joins me tonight. And she will start us off by talking about some of the legal interpretation. Are we in a legal crisis, a political crisis, a constitutional crisis? We will get to that in just a moment with her guest. But first, Sophia, what a day it's been. I mean, the IEBC must be feeling the pressure now. With every new day that dawns, there's new developments.
Good evening, Yvonne. Indeed, the Independent Electoral and Boundaries Commission tonight reeling from yet another blow from the High Court. And this time, as you rightfully mentioned, the High Court finding that they discriminated against Ekuru Aukot in excluding his name in the participation in the repeat election. And also, on the other hand, faulting the IEBC's reliance on the 2013 Supreme Court advisory, in essence saying that was an opinion which in legal language they call obiter dictum, saying it was an opinion and did not have any bearing in as far as the proceedings or tying the court to that opinion. So definitely tough times at the IEBC, and we hear from yesterday throughout today they have been in meetings trying to figure out which way forward, and a way forward in which they will not find themselves back in court again, because each of the parties involved, the stakeholders, are looking out to ensure their rights are not denied. They're fighting for them, and we've seen some of them leading us to the situation we find ourselves in. So definitely one of those very interesting scenarios we're having tonight. And joining me to speak a little bit more about this is Elisha Ongoya. He's a constitutional lawyer. He's also a senior lecturer at the Kabarak University, that is a department or school of law, if you like. And thank you so much, Ongoya, for making time for us. Let's begin with, we have become a very litigious country, but many would argue in a good way, because all of this is allowed and it's part of democracy, isn't it? What do you make of where we are?
Number one, let me point out that if there's a point in this country's constitutional history that this country has behaved well, perhaps it is now. Because this country has taken it upon itself to test its processes against the mirror of the law to confirm that at the end of the day, everything that we do is done according to the law. And therefore, the fact that a lot of litigation is taking place in the long-term context of things is a very positive thing. The law, like any other written text, is never absolutely clear. All word-based tools of human communication require some interpretation, which is where we are now. There's a lot of interpretation taking place.
Yeah.
Number two, what we are witnessing are constitutional processes in motion. This country has committed itself to being a constitutional democracy. And the constitution is now in motion. We have removed it from the text. We have now availed it in motion, and institutions and processes are testing it and being tested at the same time. So in principle, constitutionally speaking, what is happening ought to be a good thing. There is a flip side to it that is the worrying trend, the sociology of the situation, where the elements outside the law, elements like trust, seem to be waning. Now that presents a different sociological challenge. But in terms of processes, we know that the Constitution requires that we hold elections on the 2nd Tuesday of August. We did hold them. It sets up certain standards, and it anticipates that in some circumstances, we may not meet those standards, and says if we don't meet them, this is the mechanism of redress. We have exhausted that mechanism. That mechanism has said that if we find that you didn't comply with standards A, B, C, and D, you have to repeat that process. We are in the process of repeating it. In the course of that repeating, controversies have arisen, whether everybody has been given a square deal. People have gone to court about it. That's how civilized societies the world over ordinarily work. And therefore, there's nothing inherently wrong in what is happening in Kenya if we manage the sociology of the problem.
And we'll get to that, Prof. Let's talk a little bit more about the big story today, Ekuru Aukot getting that reprieve to be part of this election. Talk to us about that, but also these other candidates who are party on the 8th of August in the presidential election, but now expressing interest. Did the court, was it clear that they can all participate?
There are two things. I have taken the liberty to read the judgment of the court twice this afternoon. I found two things. Number one, the court defined what is a fresh election. At least that is something you can pick from today's judgment. And the court defined who is eligible to be a candidate in a fresh election. And the court reasonably said that every person who participated in the impugned election is eligible to be a candidate in this election. Number two, the court in its concluding orders said that the IEBC issues a fresh gazette notice or issues a colligenda gazetting Ekuru Aukot, now specifying the name. That presents a bit of a dilemma because the IEBC has to grapple with the reasoning which essentially conferred a right on every person who was a candidate in the last election. On the other hand, gave a consequential order coercively directing that Ekuru Aukot's name be put on the list. The IEBC has to put its legal team together and find what is the best way out of this situation. If I was sitting at the IEBC, I would insist on the gazettement of each and every candidate who was in the election on 8th of August.
Yeah, and in fact, some of the news I'm getting, if I'm not wrong, is that they have just sent out a statement and in fact put out a notice including all the candidates, even Raila Odinga, saying if in fact he chooses to not be party to the 26th, they say still the date, or election, then he can withdraw once again. What do you make of this development?
Well, it just confirms that my preliminary thought as I held them was not so much off the mark in terms of their thinking. What I understand is that when the court found that Gazette notice violated the Constitution, Article 2 came into force. It says any act that is in contravention of the Constitution is null and void. In law, we say out of nothing comes nothing. That act was as bad as if it was never done in the first place. It was as if that Gazette notice never existed in the first place. And therefore, one would assume that they are issuing a fresh Gazette notice now, declaring who are the candidates for this election. One would have to interrogate the law to find out if they have issued a totally fresh Gazette notice today, what is the time period of publication of that Gazette notice? My preliminary reading and I would, of Section 14 of the Elections Act is that would have to be at least 21 days to the election date. That presents a new legal challenge. I've said we are engaged in constitutional processes. It just means if somebody feels that this new Gazette notice again violates the period within which the publication must subsist for elections. Again, the legal processes are there. That's number one. The second thing that Kenyans must lose sight of is that this decision was rendered today. There is an automatic right of appeal from this decision. And if there's a right of appeal, it means there's a possibility of an appellate court overturning or confirming this decision with its own consequences. These are constitutional processes in motion. Barack Obama told us here that democracy can be very frustrating. we submitted ourselves to being a constitutional democracy as a country. We cannot opt out of it conveniently.
Right.
We have to take democracy with all its benefits and the relative frustrations that come with it.
So talk to us also about the scenario. Yesterday we saw Raila withdraw, and in essence he was withdrawing under the advisory of 2013, which today has been knocked out and kicked out by the High Court. But this ruling is today. The events of yesterday are yesterday. So does today's ruling get to be applied retrospectively back to yesterday? Because in Raila and his supporters' minds, things should work as the law stood yesterday.
Yes.
Yeah.
Now, that's another legal dilemma that we find ourselves in, but which I have said, a dilemma is not necessarily a bad thing in law. A dilemma exists by virtue of inherent ambiguities in language as a tool of communication. Anytime we communicate to people, they ask us to clarify what we have said. Now, Raila withdrew from the race yesterday. Strictly speaking, from the terms of the Supreme Court decision of 2013, it meant that a fresh nomination had to take place. A new decision has taken place today that seems to render that portion of the 2013 decision a by-the-way statement, a by-the-way remark that did not therefore constitute the core of the finding of the Supreme Court. Meaning the law as it exists today, the law as it exists as at the date when the IBC now, as we are told, has issued a fresh Gazette notice is that if there has to be any new withdrawal, we have to look at it in the context of the law as it exists at this point in time.
Yeah.
That then presents, number one, a legal question. If we withdraw as a candidate, do we proceed with the other candidates? That's a question to flag. But number two, it also presents a political dilemma. A political dilemma because the law never operates in a vacuum. If Raila Odinga's followers, whatever their numbers, then decide to say that, no, as far as we are concerned, we took some consequential action yesterday, and any consequential decision that IBC makes must take into account what we did yesterday on the state of the law that exists then that is a challenge that we again have to possibly go back to institutions of interpretation to find out what exactly would be the way out.
So we should look out for this Gazette notice, whether it's a fresh one. If it's fresh, it has issues of 21 days, because then that will be after the 26th. But also what I'm understanding is that the IBC has said they've not received the Form 24A, which is official withdrawal, saying that if he then does submit it, he will be considered to be out of the race. Then we have the fresh laws that were passed, which indicate that if a candidate pulls out, the rest continue.
There are two things. Number one, if, there's something about a law that we call the Interpretations and General Provisions Act, which the Form 24A is a form that is issued under the Elections Act. And the Interpretations on the General Provisions Act says that if that form does, if a decision is taken using a form that does not necessarily strictly conform to the form, that in itself does not invalidate the action taken. But two, and more importantly, the IBC, I saw on their website, on their portal yesterday, they had actually acknowledged receiving the withdrawal by Raila Odinga and saying that they were having a meeting fashion. So they'll have to deal with that. And what are the consequences of a withdrawal that does not, strictly speaking, fit within the four corners of the form, as it were, particularly when they have themselves acknowledged that what was communicated to them was a withdrawal. That's an interpretation question again that has to go. Laws have been passed today. A very unfortunate thing, because the world over, and I have read election processes quite a bit, it is highly discouraged to engage in amendments of electoral laws at least within 6 months to the election period. Here we are, we have amended our electoral laws barely 10 days to an election date. It violates best practices. Best practices are not in and of themselves the law. They just give us a healthy environment within which to operate. Sometimes they inspire the courts in the direction it will take in resolving disputes that have arisen around them. I see some people also taking up this issue, perhaps as a litigation question, and seeking again another intervention of the courts. So that if Kenyans are fatigued by use of the courts as a forum for these disputes, I empathize with them. I can understand the frustration. The court appears to be a nuisance here. But let's also understand that the court does not go out look for dispute. The court sits back adversarially and waits for parties to come to it. Number two, when a dispute comes before you as a court, you can't run away from it. You must resolve it, and you can't be ambiguous. You must pronounce yourself one way or the other. So these are emerging scenarios that I must tell Kenyans to brave for it. We are in a democratic process, and democracy can be frustrating, but it's the form of government we have chosen. Anything the contrary is a tyranny. And it has been proven scientifically tyrannies are worse off than frustrating democracies.
All right, many thanks. Thank you so much.
Most welcome.
Elisha Ongoya speaking with us there. And this is the form of government we have chosen, a democracy, Yvonne. And as I hand it back to you, it's one of those moments as you're just getting to wrap around your head one development, another one kicks in. And quite interesting times we're getting to live through as a country. Yvonne.
Indeed, that's right. This big story continues to develop in ways that we are only starting to understand and grapple with. Thanks, Sophia, for that. Some interesting views there from Elisha Ongoya. So if you were just joining us on the big story tonight, it was that Dr. Ekuru Aukot had his win at the courts of law today that compelled the IEBC to ensure that his name is on the ballot 15 days from today. As a result of that, this is the breaking news that is coming in tonight on the big story, and that is that the IEBC now says, based on Justice Mativo's ruling, that all candidates will be on the ballot for that fresh presidential election on the 26th of October. Once again, that all 8 candidates shall be included in that 26th October presidential election. They also continue to say that they have received the letter from Raila Odinga, who's the NASA presidential flag bearer, indicating his intention to withdraw from the fresh presidential election, but that he's yet to fill in the statutory form 24A. Once that happens, according to the statement that's been sent in, the commission will then process the same in accordance with the requisite provision of the law. So just when you thought there was perhaps no election, this is a story that continues to develop time and again. So that is a statement that's coming in today. I would like us to now speak to the man of the moment, and that is Elias Mutuma, who is Dr. Ekuru Aukot's counsel. He was his lawyer representing him in this case. Elias, it's good to speak to you. I wonder if you've had a chance to process the news that is coming in from the IEBC with respect to the verdict that's just come out in court today. What are your thoughts now? Not only will your client, Dr. Ekuru Aukot from Third Way Alliance, be on the ballot, but so will all the other presidential candidates as well.
Thank you, Yvonne. I've just seen the breaking news that IEBC has decided to include all the 8 candidates. But that was not what we were expecting, because Justice Mativo was clear. There are only 2 orders that were issued in that judgment. The first order was that a declaration that Ekuru's rights had been violated by failure to include him as a candidate in the forthcoming election. The second order was that a specific order directed to IEBC to include Dr. Ekuru Aukot in the forthcoming election. I do not know why IEBC has decided to interpret those 2 orders to include all the other candidates, especially considering that we know that most of those candidates had either withdrawn from the race officially, they had declared their support for one of the candidates. So it's a bit of some confusion, because we might also see them again seeking to withdraw from this race, which might again draw us into a greater confusion that we are in.
All right, Elias, but Justice Mativo in his ruling today actually quoted you, and this is what he said when he was quoting what you had to say, which was that upon nullification, the will of the people as expressed in the election ceased to have effect and must now be subjected to a fresh test. So some might say that in your presentation to the court with respect to this matter, that you were indeed perhaps making a case for this process to start afresh following the nullification of President Uhuru Kenyatta's win on the 1st of September?
That was one of the statements that he made.
Yes.
Dr. Ekuru did not just win because he was a presidential candidate in the 8th of August election. The other factor that made him be included in the ballot was the fact that he had actually applied to be enjoined as an interested party, and that was clear in Mativo's judgment. And he was on record as being a person who was supporting the petition and asking the Supreme Court to nullify the election because it was not held in compliance with the Constitution. So that was another ground. Most of the other candidates that have been brought on board had not applied to be enjoined as interested parties in the Supreme Court. And the only one who had applied to be enjoined was Professor Wainaina, who had clearly indicated that he was not supporting the petition. And according to him, the election had been held in in the compliance with the Constitution. So it's not just because Ekuru Aukot was a presidential candidate. There were other factors that the judge considered before making the declaration that he made.
So, Elias, do you think the other candidates are joyriding on your win in court?
That's the only explanation to it. Yvonne, we started this case the moment the Supreme Court denied us the orders that we had sought from it. We filed the case on 22nd of September 2017. None of these other parties even bothered to apply to be enjoined as an interested party in the High Court case, meaning they were just sitting pretty and waiting for us to labor and enjoy our fruit. But that's okay.
Let me ask you then about the gazettement period. What are your thoughts as to the interpretation of that order that was given by Justice Mativo, asking the IEBC to ensure that your client, Dr. Ekuru Aukot, is gazetted as one of the presidential candidates? Now, our understanding is that it would take 21 days for him to be gazetted. Perhaps you can clarify, but then there was also the amendment of the gazettement. And the reason I'm asking this is because we don't have 21 days. We've got 15 days, and that 21 days would take us outside the 60 days under which the Constitution says this election must be held. What's your interpretation of Mativo's ruling and the resultant gazettement of your client?
In the event of a fresh gazettement, it will require 21 days. But Mativo was very clear because he foresaw the situation that we are in, because we only have 15 days for the election to be held. And he said that we can have an amendment to the gazettement, which does not require the 21 days period. So it doesn't necessarily mean that we have to wait for the 21 days if it's an amendment to the gazette notice. But then there is a problem, because if, again, we are following that judgment to the letter, the judgment was as follows, that I hereby direct and order the first and second respondent, that is IBC and Wafula Chebukati, to include the name of Ekuru Aukot under the Third Way Alliance Party as a presidential candidate in the 26th of October election. So how would IBC then be enforcing that order if they have gone beyond what that order had directed? That's the question that IBC might be required to answer, and that might also draw us into, a bigger crisis than we are at the moment.
All right, so here's another one for you, because your client, Dr. Ekuru Aukot, has also raised some serious issues with the IEBC, with the manner in which they conducted the election. In fact, just for the sake of our viewers, we do remember that he, in fact, in the beginning conceded defeat and then rescinded that concession. But then he has raised some rather serious issues with IEBC. Is he prepared to then be part of this in the 15 days, noting some of the issues he has raised, which he even did today outside the court, reiterating them? Does he have some irreducible minimums or certain issues that he requires be sorted out by the IEBC before the 26th of October?
Number one, it is true that Ekuru Aukot had made a statement that was widely interpreted to mean that he had conceded the election. But if you're keen to follow the proceedings in the High Court and in the Supreme Court, he explained himself by saying that that decision was based on the advice that he got from one of his agents, whom he fell out with thereafter, after realizing that that agent had misled him. Therefore, he rescinded actually that concession and actually wrote to IBC saying that I now revoke the signatures that had been appended by my agent. That's one. Number two, a lot has been happening, Yvonne, right from the day the Supreme Court rendered its judgment. And we have been seeing engagements, reforms from both Jubilee and NASA on the kind of reforms that I expected. Jubilee is in Parliament with the laws that they've already passed today, and NASA is in the streets trying to, reform the IBC. So Ekuru Aukot lives in Kenya and knows what happened, and you would expect him also to have issues that he might want addressed. It does not mean that they are irreducible minimums, but he said that he'll engage IBC on those issues, and I know him to be a sober man. If his demands will be reasonable, not actually demands, but issues that he wants addressed by IBC, considering that a lot has been happening. We have seen IBC engaging the other parties, coming with, memorandums and all that. So it's also good that his voice is heard before we can go to this election. But I do not think that he has irreducible minimums per
yes,
se.
but will he be making his concerns known to the IEBC? Will he be seeking a meeting with them to raise his concerns? Considering we've got, 15 days to that, and we've seen the IEBC's response to NASA's irreducible demands. Like you said, we've seen what's happening in the National Assembly as well. So will he be seeking a meeting with them? And what would happen if his concerns are not addressed by the IEBC? Would he still go ahead with it?
One thing that has been happening, Yvonne, is that the engagements that have been happening with both Jubilee and us have not been genuine per se. That's why we've not been able to come up with any solution. I believe Ekuru Aukot is genuine in his quest, and 14 days are more than enough for them to engage soberly and honestly. And we do not even need 14 days. 1-2 days are enough as long as people are clear on what they want and they do not have any ulterior motives that are driving them. If it's an honest engagement, I do not see why 14 days are not adequate for the issues to be addressed and agreed upon.
And what would those specific issues be, Elias, that he would have and want addressed by the Electoral and Boundaries Commission?
Pardon?
What would be those specific issues that he would want addressed that you say you believe can be done, in a matter of days?
I do not want to preempt his statement because he said that he'll be issuing a comprehensive statement within 1 or 2 days. So let's wait until he talks about them. I'm only his lawyer who was representing me in court. I do not speak for him in other matters. So let's wait until he has cooled a bit and he'll tell us what he has in store.
Okay, all right. Elias Mutuma, who's Dr. Ekuru Aukot's lawyer in that case today, in which Dr. Ekuru Aukot will now be on the ballot. We've also heard from the IEBC as a result of that ruling saying that all 8 presidential candidates will now be on the ballot. That's their interpretation of Justice Mativo's ruling today. Elias Mutuma with me saying the other candidates are joyriding. They were not party either to the presidential petition that was at the Supreme Court, nor this one that was filed by Dr. Ekuru Aukot. We'll be hearing more from him in just a while. So, Elias, please stay with me. This is the big story tonight, unfolding in ways that we are only starting to report to you and update you on. We're taking a short break, but also when we return, we'll be speaking about another matter that is before the court, and that is by Okoiti Omtata, where he's seeking to ensure that President Uhuru Kenyatta is not declared president. We'll be asking him whether that has now been overtaken by events. All of that is coming up next here on The Big Story. Stay with us.